Good afternoon. My name is Preet Bharara, and I'm the U.S. Attorney for the Southern District of New York. I think everyone knows by now that my office's commitment to long overdue and permanent reform at Rikers Island is total. First, that means holding individuals accountable and punishing them, and we have done that. If you just look to the chart to my right, you'll see what I'm talking about. 3 months ago, we convicted Correction Officer Khalif Phillips for smuggling drugs into the jail. Last Friday, we convicted Correction Officer Austin Romaine, who took bribes and conspired to smuggle drugs into Rikers Island. And just yesterday, we convicted former Rikers Island Captain Terrence Pendergrass, who violated Jason Echevarria's constitutional rights by deliberately ignoring his pleas for help and depriving him of urgent medical care, leaving Echevarria to die alone in his cell. That is, by the way, we believe the first criminal civil rights conviction of a Rikers officer in more than a decade. And all of these Rikers officers now face time in prison as inmates themselves. And we have still other investigations into individuals who abuse their power at Rikers Island. But our work cannot and does not end there. We will continue to press forward to demand sweeping institutional reforms at Rikers Island. That is what brings us here today, as we have taken another step in our broad civil rights investigation of conditions at Rikers Island. As you know, more than 4 months ago, on August 4th, I announced the findings and recommendations of our civil rights investigation into the treatment of male inmates at Rikers Island between the ages of 16 and 18. I explained our conclusion that there is a pattern and practice of conduct at Rikers that violates the constitutional rights of these inmates, that Rikers Island is fundamentally broken, and that brute force, verbal insults, beatings, and a culture of violence persist. I said that something is very wrong at Rikers and that reform is long overdue. And I urged the city, in the strongest possible terms, to take our recommendations seriously and act quickly to remedy the unconstitutional conditions detailed in our report. 49 days later, when the statutory waiting period ended and all options became available to us, I issued a statement reporting, among other things, that my office was engaged in discussions with the city to ensure that it was moving swiftly to implement reforms. I said that our dialogue was ongoing, but also that we stood ready to take legal action to compel long overdue reforms at Rikers if that became necessary to get to the finish line. That time has now arrived. Today we have taken a legal step that we believe is necessary to ensure that critically important reforms are implemented at Rikers Island and that those reforms are enduring, enforceable, and verifiable. In our view, there must be, at the end of the day, a court-ordered agreement. Specifically this morning, we filed a motion in federal court to intervene in a private lawsuit against the city called Nunez versus the City of New York. The plaintiffs in the Nunez suit allege that the city is engaging in a pattern and practice of using unnecessary and excessive force against inmates at Rikers Island. The allegations in that suit overlap significantly with the conduct described in our report, including allegations that Department of Corrections staff use force against inmates as punishment, beat inmates in locations without video surveillance, fail to accurately report use of force incidents, and conduct inadequate use of force investigations. We are moving to join in the Nunez suit under a statute which provides that the government may intervene in a lawsuit that seeks relief from conditions of confinement that deprive inmates of rights protected by our Constitution, so long as the Attorney General certifies that certain prerequisites have been met. The Attorney General has done that here and strongly supports the action that we are taking today. Before we file today's motion, you should know that we asked the city if it would consent to our intervention in the Nunez suit. Last night, the city did consent to our joining that lawsuit. We view that choice as a positive sign, indicating the city's willingness to continue a dialogue with us, one that we hope will culminate in an agreed-upon, court-ordered resolution of our complaint. But we will not let up in our pursuit of justice for inmates at Rikers Island, wherever that leads. The 36-page proposed complaint explains in detail the egregious and flagrant conditions of confinement at Rikers that have deprived these inmates of their rights under the Constitution. Like our August report, the complaint focuses on three main areas: the use of force by staff, inmate-on-inmate violence, and the use of punitive segregation. To recap briefly, we found and allege in our proposed complaint that staff use force against adolescents with alarming frequency, blows to the head are widespread. Rather than using force as a last resort, corrections officers use force to punish, taking inmates to isolated locations with limited or no camera coverage to inflict beatings. The department allows a powerful code of silence to persist at Rikers. The department fails to conduct timely and thorough investigations of use of force incidents. The department fails to adequately discipline staff for using unnecessary or excessive force against the adolescent population. The department fails to provide correction officers with adequate training in appropriate use of force. Inmates charged with committing rule violations, including nonviolent infractions, have been routinely placed in what amounts to solitary confinement for weeks and sometimes months at a time. This is a point that I emphasized in August when we issued our report. And after we issued our report in August, the department announced that it was stopping, and then yesterday the mayor confirmed that it was stopping the use of punitive segregation for 16 and 17-year-olds by the end of the calendar year. And although we applaud the commissioner for this decision, we believe court-ordered relief is still necessary to guarantee that this long overdue change is permanent and verifiable and won't revert back if there happens to be a change of heart or a change in leadership. In addition, the department continues to place 18-year-olds, including those diagnosed with mental illnesses, in punitive segregation for lengthy periods. Now, there have been, without question, positive developments since we issued our report. The mayor recently acknowledged that, quote, Rikers Island has been a dehumanizing environment, close quote, where violence has become, quote, entirely too common and was tolerated, and that the institution deeply needs a culture change, close quote. Also, in response to our report, Commissioner Pont has taken several good steps with respect to the 16 and 17-year-old population, including improving the staff-to-inmate ratio, developing new programming, and moving towards eliminating the use of punitive segregation. So we appreciate all of that. We appreciate the mayor's visit to Rikers Island yesterday and the good steps taken so far. But in our view, much, much more needs to be done to safeguard the constitutional rights of inmates at Rikers Island and to ensure that it is a safe and secure environment, not just for the inmates, but for the staff also. Just from September through November of this year, for example, there were 132 use of force incidents by staff involving inmates between the ages of 16 and 18. Those numbers remain way too high. We have now had a number of meetings with the city concerning the recommendations in our report, and we have made progress, but we need more. The bottom line is that reform must be permanent, and by that I mean legally permanent. Sometimes it's the case that bureaucracy can get in the way of reform-minded thinking and comprehensive cultural change. We hope that won't be the case here. We absolutely welcome the aspirations articulated by Commissioner Pont, but we hope those aspirations will find concrete expression in the form of permanent, enforceable, and verifiable terms in a court-approved settlement agreement. The devil, as they say, is in the details, and we have come to the conclusion that joining the pending case as a formal party is the best and most efficient way to get those details done. That is why we are now taking the steps necessary to carry out our responsibility under the law. Given the long-standing, sad state of affairs at Rikers Island, our impatience is more than understandable. As I've said before, one way or another, we will get enduring and enforceable reform at Rikers Island. Now, before calling up the Acting Assistant Attorney General to the podium, I want to thank some folks who got us to this point. I want to thank the Board of Correction for their continued assistance in connection with this office's investigation. I also want to recognize and thank the dedicated prosecutors and paralegals in my office for their outstanding work. The Assistant U.S. Attorneys are Emily Daughtry, Deputy Chief Appellate Attorney, Jeffrey Powell, Lara Ashkenazi, and David Kennedy, the Chiefs of the Civil Rights Unit, and Sarah Shadovsky, Chief of the Civil Division, and the paralegals who worked on this case, Tammy Yin and Jamie Tovar, and of course, all the leadership and support from the Justice Department, including from the Civil Rights Division in the form of Vanita Gupta and Mark Kappelhoff, and of course the Attorney General of the United States, who has personally signed off on our motion to intervene in this case. And now I'm pleased to call to the podium Vanita Gupta, the Acting Assistant Attorney General of the Civil Rights Division of the Department of Justice.
Thank you, Preet. It's an honor to join you to announce the filing of this very important piece of litigation. The enforcement of the nation's civil rights law is really a partnership between the Civil Rights Division and the U.S. Attorney's offices around the country. And your office has really been a leader in this effort. You and your team have undertaken many important civil rights initiatives, including your critical work at Rikers Island. As Preet mentioned, we are here today to announce our intervention in a class action lawsuit against New York City over a pattern and practice of excessive force and violence in New York City jails on Rikers Island that violate the constitutional rights of adolescent inmates. The authority to deprive individuals of their liberty and place them in a prison or a jail is one of the most profound powers of the government. With the exercise of that power comes the responsibility to ensure at least minimum standards of care and protection are observed. And our Constitution recognizes that individuals who are incarcerated have the right to reasonable protection from violence and to be provided the basic necessities of life. These are not only essential constitutional principles, but really good public policy and fundamental to public safety and the safety of correctional staff. When government fails to meet these basic responsibilities, the Department of Justice stands ready to appeal to the courts to ensure that basic rights are respected. Today we are doing just that. We're taking legal action to ensure that critically important reforms are put in place to address conduct reflecting a culture of violence at Rikers Island, a culture that has violated the constitutional rights of New York City's youngest inmates. The mandate to ensure safe and humane conditions in the jail is never more important than when we incarcerate young people. The findings of the investigations of the United States Attorney's Office can only be described as deeply disturbing. Young people are subject to unnecessary and excessive violence by staff and to the overuse of punitive segregation. They are not protected from other inmates. This suit is essential to bring urgent and necessary and sustainable and permanent change to the conditions at Rikers Island through a court-enforceable agreement. The Civil Rights Division works to address unconstitutional conditions in prisons, jails, and juvenile facilities around the country. For example, from Cook County, Illinois, to New Orleans, Louisiana, to Muskogee, Oklahoma, we have reached cooperative agreements that ensure that people in prison are treated humanely and consistent with the Constitution. From that work, we have learned, sadly, that Rikers is not alone. In far too many places, youth held in adult jails are subject to abhorrent and abusive conditions. We have also learned that mistreatment, violence, and neglect are not inevitable. The problems we see on Rikers Island can be fixed. Reform works, and the changes that we seek will not only ensure that the rights of youthful inmates are protected, but will make a safer workplace for correction staff and promote public safety. Most people in detention facilities and prisons return to their communities following incarceration. So if our compassion does not motivate us to ensure that youthful prisoners are treated with a minimum of decency, our self-interest demands it. The conditions in which they're confined, the services that they are provided, and the opportunities that they are given are critical to their ability to succeed when they come home. We can make our kids better or worse by the way we treat them when we lock them up. Moreover, the adverse and dangerous conditions that prevail on Rikers Island place the lives and safety of staff at risk. It is clear from our investigation that our corrections officers do not have adequate programmatic options to deal with an admittedly complex and difficult population. The risk is compounded by the failure to give staff sufficient policy guidance, necessary training, support through supervision, and very important accountability systems. These systems failures create a toxic mix that harms prisoner and staff alike. We recognize, as Preet said, that the city has taken initial steps to reform, and we applaud the mayor for his public commitment to fixing the problems. We are committed to working with the city to get at the core issues. And through this litigation, we seek a court-enforceable agreement that will ensure endurable reform that would make very important changes. We seek that excessive force will be prohibited, that staff will be trained to de-escalate and maintain control without excessive force, and that when force is used inappropriately, it will be identified and addressed. We seek to ensure that necessary steps will be taken to protect youth from violence, and that other necessary measures are taken to ensure that the rights of adolescent inmates are protected. It is our sincere hope to resolve these issues with the city through a court-enforceable agreement in order to implement sustainable systemic reforms. We also hope that this matter can be resolved quickly so that all available resources can be directed at fixing the problems and not in litigation. Thank you.
Thanks, Vanita. Happy to take your questions. Yeah.
Are you going to ask the court to appoint a federal monitor?
It's premature to talk about, what form the ultimate resolution will take. But in our mind, based on our experience and the longstanding experience of the Civil Rights Division of the Justice Department, in order to have enduring, sustainable reform, it's typically the case that you want to have some kind of outside independent oversight. What you call that person is not as important as making sure that you have that kind of independent oversight. And I will note that I have optimism about that because this administration has taken the position that that kind of outside oversight is incredibly important with respect to another law enforcement organization. So we'll wait and see. I don't want to prejudge anything, but that's usually how it works out. Yeah.
Can you explain some of the stumbling blocks in the last, in the months since your report came out in August? What did the city fail to do to meet your criteria so participate in making an honest effort to react quickly enough to some of the problems that the report brought up?
So I don't want to characterize issues as stumbling blocks. I also don't want to get into the negotiations that have been going on. I don't want to over-dramatize it. As I said in my remarks, the city has done great things. And as I said when I first announced our report, it was very encouraging to hear the kinds of things the mayor was saying, Corporation Counsel was saying, and Commissioner Pont was saying. And they continue to say good things. And more importantly, they continue to engage in good acts. And as I said, given the longstanding sad state of affairs, we are understandably quite impatient. And we would like things to get done at a faster pace. And more importantly, we think at this juncture, having stayed our hand for a period of time, that the most efficient way to go about getting the absolute best concrete details in written form, really, to be approved by a court, was for us to join formally as a party. I will note also, on the bright side, that the city invited folks from my office to participate in discussions with the Nunez plaintiffs even before we formally moved to intervene in the case. So things have been going well in some regards. On other issues, there have been differences of opinion. I don't want to get into them because it's improper to get into settlement discussions. But we should take from our action today, given that it didn't happen on the 15th day when we were legally able to intervene, or on the 49th day when we were legally able to file our own independent suit. We have been working well with them, but we think things can go faster and things need to be etched out in greater detail in concrete terms rather than in broad aspirational terms. Yeah.
Has the Nunez class action been on the U.S. Attorney's Office's radar? And what role did that have in prompting this investigation that started off this?
Yeah. So the Nunez suit was filed initially as an individual suit, I believe, in 2011, and then became a class action suit in 2012. And we have a very broad radar screen, so everything is on our radar screen, as you know. And obviously, our report dealt with a certain subset of inmates at Rikers Island, the adolescent population, 16 to 18-year-olds. But as we said, obviously, there's a lot of overlap between what we were looking at and what we investigated and what the Nunez plaintiffs have been looking at and have been alleging. So there's a synergy there, and that is another reason why we thought that the best and most efficient way to go forward was to intervene in that lawsuit rather than bring our own separate one, which I think the worry was that would prolong matters. We have no interest in prolonging things. Our interest is in getting to the bottom line and the finish line as soon as possible.
Just a quick follow-up. Did the Nunez case alert you to the problem? That did that in any way spark the investigation?
As I said before, we are constantly looking at things, and we've had our own cases, as I've described. These are recent ones. We've had other ones before. Other DA's offices have brought cases. So the problem at Rikers Island, by the way, did not originate in 2011 or 2012. They've been going on for a very, very long time. So it's the kind of thing that has been on a lot of people's radar screens for a while. But obviously, the information that has come to light from the Nunez suit was of some aid. Yeah.
These consent decrees often last many years, a decade or more. Is there any reason you think that will be different? And also, do you think, do you have any indication of whether COBA, the union, will cooperate or perhaps try and hinder your efforts?
Yeah, I don't want to speculate about what the union will or will not do. I think that the statements being made by a lot of people, including by folks affiliated with the union, have been generally positive, but not unanimously positive. I also want to prejudge how long any consent decree, if that's what happens, would exist. I mean, the point of these things is to make sure, as I have said and as Vanita said repeatedly, is to make sure that reform is there. That's the first job, but that it is not ephemeral and it doesn't go away. And however long that takes, we would expect that's how long such a decree would last. Yeah.
Can you talk to the fact, a lot of people, when they hear people on Rikers, they think that they are criminals and have actually been convicted, where a lot of times, these are young folks who are just waiting for a trial and can't even afford $1,000 bail. It's more troubling that some of these folks are
Yes.
actually innocent there and being abused.
Yeah, the presumption of innocence is an important thing in our system. And it's not only troubling that we're talking about use of violence in connection with our investigation against young people, 16 to 18-year-olds, the most vulnerable people in the criminal justice system, but also people who are pretrial who have still the presumption of innocence attached to them. And also, as I mentioned last time, and as detailed in our papers, something like 51% of folks who are in Rikers Island have been diagnosed with some form of mental illness. So you're talking about really as vulnerable a population as I think you can have in the criminal justice system. And if these kinds of allegations were being made with respect to less vulnerable populations, it would still be appalling and stunning and upsetting to anybody who believes in equal rights for everyone. But it's, as you say, particularly troubling when it applies to this population. Yeah.
Do you see the city as an adversary in this or an ally or something?
You should ask them. But just because they're on the other side of the V doesn't mean that we have to be scorched earth adversaries. As I've said, I've taken great pains to say, when I've spoken to people at the city and when I've made public remarks, that we are very encouraged by all the things that people are saying they want to do. So again, I don't want to overstate in any way the action that we're taking. I mean, the filing of a motion to intervene in the suit, to my mind, is not a declaration of war in any way. It is an act of resolve to make clear that we intend to be a formal party at the table for all negotiations, and that the things that get accomplished are sustainable. That's how I would characterize it. Yeah.
As you just mentioned a moment ago, there are a lot of problems with Rikers. This suit is pretty narrow in its scope because of what it's trying to focus on. Are there other things that you're trying to get the city to work on and develop to fix other problems? Can you sort of describe the width of this negotiation with the city?
Yeah. Part of the reason to have joined the Nunes suit is you're right to say that our suit, that our investigation did not cover everything that goes on at Rikers and was focused on a particular vulnerable population. But as we also outlined in the proposed complaint and outlined in our report, there's a lot of overlap because issues about punitive segregation apply to everyone. Issues, although maybe more poignantly to a younger population, issues with respect to cover-ups, issues with respect to codes of silence, that's applicable to everyone in the population. So a reform of investigative procedures, a reform of disciplinary procedures affects everyone, not just certain slivers of the population. So in that sense, I think what we're trying to accomplish is quite broad. You asked a question about what other things we're trying to accomplish. I think it's very important, whether you're talking about banks or you're talking about hedge funds or you're talking about a prison institution, that you do two things. And that's why I wanted to make the point that I made today that's exemplified by the chart. On the one hand, you want to make sure that individuals who have done bad things are held accountable and they're punished. And you've seen the majority of corrections officers are good, noble, do the right thing people who have a very, very tough job. But there, unfortunately, have been a lot of bad apples. And our intent is to prosecute them in a tough and aggressive way. And we've done that in the cases I described here, and we have more cases potentially coming up. But that's not enough. And every once in a while, in different contexts, someone suggests that the only thing you have to do is prosecute individuals, and then everyone gets the message, and that's deterrence, and we can all, hold hands and sing Kumbaya. It does not work that way, because institutions need reform in a broad way also. And I think this case exemplifies that. And so what we're trying to do is make sure that individual guards who are thinking about breaking the law and violating a young, mentally ill, presumed innocent inmate's constitutional rights will think twice, because you're going to be an inmate yourself if you do that. But at the same time, in conjunction with the Civil Rights Division of the Justice Department, we want to make sure that we don't have those things happening in the future again. So you want to have, in the broadest sense possible, reform that means punishing individuals who do bad things and also making sure that the systems that are in place change the culture of the place so you don't have people doing bad things in the first place. Last question.
You said the city agreed last night to the consent to the motion intervening. Was there some hesitancy on the city's part?
No, I don't know if there was or not. We asked the question, and we received a positive response. Okay. Thanks, everyone.